Martin Bryant was convinced to plead guilty by his defence attorney. John Avery later on was charged and convicted of misappropriation of his client's funds. Welcome to the WASP Files. Some of this material may be distressing and viewer discretion is advised. Who was John Avery? John Avery is quite a dubious character, and that's not my opinion solely. The facts alone speak to the nature of his character. John Avery was appointed as a second defence lawyer for Martin Bryant. In my opinion, I use that term very loosely because in my opinion, John Avery's defence of Martin Bryant was totally inadequate. Now, guilty or not, everyone is entitled to fair representation under the law. So one of the issues with John Avery was that he went to Coronial Bryant, Martin's mother, and said, look, you've got to help me convince Martin to change his plea to guilty, because Martin had staunchly held a not guilty plea for 5 months while he was held in solitary confinement. Carleen confessed in her book that this was the case. Her book's called My Story, which is available. And she went to the prison with John Avery, his defence lawyer, and said, if you don't change your plea from not guilty to guilty, you'll never see me or your sister Lindy again. Result, Martin changes his plea to guilty, case closed, no need to have a trial or suggest evidence or bring witnesses, thrown in jail and toss away the key. So I don't consider that a very strong defence. At the time, John Avery has basically stated that he felt that the facts of Martin's guilt were unassailable, and that therefore the best thing he could do is cop a plea deal and plead guilty. There was no deal per se, because Martin, of course, received consecutive life sentences and will die in Risdon prison. However, there is some question as to the propriety of the fact that Martin could enter a guilty or not guilty plea in the first instance, because in 1993, the Hobart Supreme Court issued a guardianship order basically determining that Martin Bryant was mentally incapable of handling his affairs and that he needed a guardian to be able to adjudicate his affairs. So in that instance, if someone is that mentally incapable, and if they're determined to have an IQ of 66, I would have thought that a defence attorney would try to press for a case of diminished responsibility due to mental disability, or the fact that that perhaps because he was held in solitary confinement, there were some issues. One of the statements that Martin made in the unredacted police transcript, which is available to download from this site and from these episodes, is that he was, in essence, tortured in prison, in solitary confinement. He mentioned that he was made to lay down on his burnt back, which he sustained during the fire at Seascape, and they pulled my arms up behind my head. That piece of salient information, along with 65 other pages, were redacted from the transcript that was read out in the pre-trial court hearing. So I guess if that came out and the defence lawyer had that, they could say, hey, this person stated that they were tortured in prison, which would perhaps bring into question any kind of confession. The notion, too, that he'd been held in solitary confinement with totally restricted access to the media and to very few people that he could see for 5 months also suggests that there should have been perhaps more rigorous kind of protocol in terms of getting him assessed, interviewed, basically determining his guilt. I think John Avery didn't do that. I think John Avery basically just took the way out to get him to plead guilty, and that as a result of that, there was never any trial. And as a result, we don't have access to all of the hard evidence, the forensics, the ballistics, and the DNA that were collected. Very, very important witnesses, some of whom contradict the mainstream story about who shot them at Port Arthur. They were never able to have their day in court, to have their say. People who wanted to bring a case for the Ock Health and Safety failure where the fire door was locked at the Broad Arrow Cafe, resulting specifically in 7 people being shot dead trying to escape the cafe, never got their say in court either, because the trial was squashed because Martin Bryant was convinced to plead guilty by his defence attorney. John Avery later on was charged and convicted of misappropriation of his client's funds, and was purchasing like art and other items. And so it calls into question his character to a certain extent. He recently has been interviewed a few times, and he certainly has literally played the victim and said, I was one of the victims of Martin Bryant in the way he was treated. I have to say that I felt that to be insincere, and I felt that as a defence attorney, whether it's by reasons of insanity or the diminished mental responsibility, there should have been a trial. Martin should have been given at least the opportunity to speak, to be able to be cross-examined, to then determine what was going on with him, whether he was guilty, whether he had some mental capacity that caused him to carry out the massacre or didn't. If he had some indication, as he has mentioned to people in prison, that there were other people involved in the event, that would have come out, you would imagine, in a trial. But no trial, so none of that has ever been able to be investigated either. So in terms of John Avery, I believe that I would not want him to be my defence attorney. I think he sold Bryant down the river, probably to appease, a justifiably angry Tasmanian community and the authorities at the time. But that shouldn't preclude your duties to provide a fair and just defence of your client. Thank you for joining us for this episode of the WASP Files. Feel free to share far and wide and see the attached files in support of the episode. Thank you.